hallway. Could we bring in the attorneys from everybody can come in. Thank you, folks, for your patience. We have been handling a juvenile matter which is not public, so I apologize for having the camera and the video turned off, but there were some things we had to do that were not public. All right, folks, we're going to start on our first appearance docket. Once everybody comes in from the hallway, we can start. All right, let's call the matter of, and we're going to take three people out of order first. The first is Mr. Mark Gonzalez-Dolden. But before I take Mr. Gonzalez-Dolden, let me talk to everybody first. And I ask that everybody who is going to be on the first appearance docket today listen up, because these are things that are important to everyone's case. And I'm going to say them once in the beginning so that everybody can hear them at the same way. Good morning, everyone. My name is Dan Casey, and I am your judge this morning for your first appearance hearings. Let me tell you a little bit about what first appearance hearings are. First appearance hearing is a limited hearing. Thank you. With three main purposes. The first is I will tell you the charges for which you were arrested. Second, I'll determine whether probable cause exists for that arrest. And third, after consulting with the state and your counsel, I will determine your initial conditions of release. Let me tell you what first appearance hearings aren't. Today's hearing is not a time to address the facts of your case. That will come at a later time when you are assigned in front of your regular division judge. Let me remind you that everything that we say at this hearing today is being recorded, and that you have the right to remain silent, and if you say anything about your case, it can and will be used against you. So I advise you that if you want to talk to me about anything relevant to the first appearance hearing, you not mention or talk about the merits or the facts of your case, because that frequently just doesn't work out well for people. I also want to advise you that you have the right to counsel. Attorneys from the Public Defender's Office are here in court with me, and they will be representing you unless you have private counsel. If you've retained private counsel, your counsel obviously will be representing you, and they will be in court here with me as well. You also have the right to consult with your attorney, with your family and friends, and you please let me know if you need additional time to do that. All right, folks. So let's start with Mr. Gonzalez-Dolden. Come on up, sir. Good morning, sir. How are you?
Morning, Your Honor. Scott Kalich on behalf of Mr. Gonzalez-Dolden.
Good morning, sir. All right, Mr. Gonzalez-Dolden, you have been charged with touch or strike battery in a domestic violence situation, and count 2, obstruct, deprive of means to protect or communicate. Do the parties wish to be heard on probable cause?
They are.
All right, I'm going to find probable cause, and I'll hear from the parties on conditions of release.
Judge, well, the state, is the state
I'm sorry,
contacting the victim?
Main Jail, could you turn off the microphone just for a moment? Sorry, folks, I'm getting handed a lot of stuff, and I'm just, okay, got it. All right, I'll hear from the parties on release.
Sure. In this case, the state is requesting a $1,000 bond on each count, as well as a no victim contact order and a no return order.
Your Honor,
Defense?
I would just ask for a $500 bond on the misdemeanor battery and a $500 bond on the felony.
All right, I'm going to issue a $1,000 bond on count 1 and a $500 bond on count 2. I also have a no contact order with the victim. with the alleged victim, and no return to the scene.
Go back and get any personal belongings?
Of course.
Okay.
All right, so Mr. Gonzalez Doldan, I've issued you a bond in your case, but I've also issued two other orders that I need you to understand. First is I've issued a no-contact order with the alleged victim. What that means is you can't have any contact with her. You can't be in the same place at the same time that she is. You cannot have any phone contact, no email contact, no text contact, no social media contact, no texting, no contact of any kind, either directly from you or through a third person. Do you understand that?
Yes, I do.
And secondly, I need you not to return back to the scene of the alleged incident. If in fact circumstances change, your counsel can always bring a motion to your regular division judge. But for right now, I want no contact with the victim and no return to the scene. Do you understand that, sir?
Yes, I do.
Thank you so much. I wish you very good luck.
Okay.
Thank you, counsel.
Thank you, Your Honor.
Jay, take your hand out your pants. We don't do that in here. Take them out.
Okay, let me see if I can find it. Yeah. I thought I had written it down that way. No, see it here. We'll catch you. All right, folks, next we're going to call Christopher Anthony Park. That's also out of order.
Mr. Park, how are you?
Good morning, sir. Good morning, Mr. Park. How are you, sir?
I'm well, thank you.
Mr. Ansetta, could you,
Yeah.
you announce your appearance, please?
Sure, Judge. Richard Ansara on behalf of Mr. Park.
Okay, Mr. Park, your lawyer, Mr. Ansara, is here in our courtroom here. I want to let you know that you've been charged with battery caused bodily harm in a domestic violence circumstance. Do the parties want to be heard on probable cause?
I do actually, Judge. A little confused on the charge because I believe the face sheet says misdemeanor battery, but the substantive portion of the PC indicates it's a felony battery charge. So what charge is it?
State?
Basically, this one I'm looking for is coming up as a first-degree misdemeanor.
So it's the state's position that the charge for which Mr. Park was arrested as a first-degree misdemeanor. Is that right?
That's my understanding, Judge. Just one moment to look this up. Coming up as a misdemeanor battery on my system as well.
All right, then I'll find that there's probable cause on the misdemeanor battery.
Misdemeanor battery, Judge. Excellent. We do have one issue pertaining to the no contact order, Judge. The alleged victim is in the courtroom and wishes to address the court.
Shirley, come on
Sure.
up.
Come on up, LaToya.
Ma'am, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Ma'am, could you tell us your name and your address?
Okay, my name is Latoya Moore. I reside at 115.
Get a little bit closer to the microphone.
I'm sorry.
That's okay.
Okay, so you weren't thinking about that when
My
you
name
were
is
going through
Latoya
all
Moore.
this?
I reside at
Were you thinking about it?
11575 City Hall Promenade in Miramar, Florida, 33025.
Okay, ma'am, and what would you like to tell me?
First of all, I've known Christopher for over 25 years. We've been in a relationship for approximately five and a half. There's never been any violence. I've never felt threatened. He's never been physically combative towards me. The night of the incident that happened, I was
Okay, so one more
I had
time,
some
how did
alcoholic
that happen?
beverages, and what ended up
No,
happening
no,
was we
tell
were
me,
at
tell me
a
what you started off telling me
friend's
before.
home, and we had two other friends that were having an issue. Mr. Park, being the person that he is,
Wait,
pulled
wait, slow down.
the gentleman aside to talk to him, and the same thing he did the same thing with the female.
Mm-hmm.
Towards the end of the night, they
Go
got
ahead.
into another situation.
Hold on a second.
Okay.
Mr. Emelise, could you move the microphone away from Mr. Emelise? Thank you. I'm sorry, ma'am, go ahead.
No problem. Throughout the night, that same couple got into another situation. I pulled them aside to try to de-escalate it. And while talking to the female, I ended up talking to her for like 45 minutes. Then I started speaking to her boyfriend. At that time, it was about 1:30 in the morning. And Chris was like, babe, we gotta go. I said, give me a second, because I was trying to squash their situation. I didn't want it to escalate. And so he came back again and was like, we gotta go, it's getting late. And I was like, you know what, just go ahead, go. I'll have him take me home because we lived right around the corner. He left. Honestly, I wasn't expecting him to leave, but he went ahead and left. The couple drove me to my house. The car ride was real awkward, obviously. When I got to the house, I asked Chris, I was like, listen, don't leave me no more. And he was like, yeah, you told me to leave. I was like, I understand that, but I didn't like that feeling. So next time we come together, we leave together. So he was like, okay. And what ended up happening, he was like, well, you can ask, and he named one of our other friends. They would understand where I was coming from. Me being intoxicated, a little bit under the influence of alcohol, I went to the phone to call and be like, well, we'll see whose side that person will be on. And I went to call. Keep in mind, it's about, if I can remember, after 1 o'clock, I want to say around 2. That's when Chris was like, it's too late for you to be calling them. So he was trying to take my phone. In the process of taking the phone, I felt pressure on my face. I got up, looked in the mirror, I saw blood. I automatically panicked, I ran out, and by feeling the pressure on my face and blood, I assumed that he punched me. Called the ambulance, and this is why we're here. Now, my issue is I have, as you can see, my fiance is not a small guy. He's a very big guy. If there was any punch to the face, I would have some type of bruise. I do have a scratch on my nose. And what I'm thinking happened is while we were talking, while he was trying to take the phone away from me, I can show you my cell phone. They have ridges on it, and I'm assuming that the cell phone is the pressure that I felt, and it cut my nose. But I don't have any fear to be around him or anything of that nature. I'm not threatened. I'm not scared of my life. I've been with him for the past 5.5 years. We don't have those type of issues. I think what happened was I made a bad assumption, and my judgment was impaired because of the alcohol. Not saying that that's, that's right, but I'm being honest.
State? Thank you, I'm sorry, thank you,
Okay.
ma'am. You may have a seat. State?
The state's requesting on this case $1,000 bond as well as a no victim contact order, no return, Your Honor. I understand that the victim is present and did speak on the record. However, the state does have a concern based on the allegation on the probable cause affidavit of the surrounding circumstances of the actual battery. So the state is still requesting a no victim contact order as well as a no return.
Judge, if I may.
Mr. Ansara.
Yeah. I did take a look at the PC. The PC indicates that the defendant punched the victim in the nose. I think that looking at the size of this gentleman, not a small guy, frankly, even a small guy, would leave a serious injury if somebody were to actually be punched in the nose. Based on the testimony from the alleged victim in the case, that she was intoxicated, that it was a misunderstanding, I think it wouldn't be a good idea at this point to put a no contact order, because all that's going to do is give him nowhere to go, especially in the middle of a crisis situation. You can't even get a hotel. There's nowhere to go. I would ask that the court impose a no harmful contact order. I think that would be appropriate and could still serve the same means. But at this point, Judge, with the courts essentially shut down, there's no real simple way for me to file a motion to vacate the no contact order in front of the trial court in a timely manner. With everything that's going on and the victim's testimony, I would ask the court not to issue the no contact order. And if the court were inclined to issue some sort of a no contact order, we could simply do a no harmful contact. I think it would achieve the same goal.
All right, anything further from the state?
The state would object to a no harmful victim contact order. The state is still requesting a no victim contact order.
Okay. I'm going to order a $1,000 bond and a no harmful contact order. I think the testimony of the victim I found to be heartfelt and genuine.
Thank you, sir.
Sometimes those types of testimony are less so. I found hers to be sincere. And so on that basis, I will issue a no harmful contact order.
Thank you, Judge.
Now, Mr. Park, do you know what that means? I'm sorry, let him, there you go.
No, please. No, please explain.
Okay, what it means is, you're allowed to have contact with the alleged victim in this case, but you can't do anything to harm her. And if you do, then that will subject you to a reconsideration of your terms of release. Do you understand that?
Fair enough. Yes, I do.
Thank you so much, sir. All right, thank you. Thank you, Mr.
Judge
Ancera.
Casey. Have a nice one.
Thank you, ma'am. All right, and the last person out of order is Alex Rivera. Hold on, Mr. Rivera. Okay, Mr. Rivera, you're represented by counsel who's here in the courtroom. Counsel, can you please announce your appearance?
Yes, Judge. Carson Hancock on behalf of the defendant Alex Rivera for purposes of the magistrate hearing.
Good morning, Mr. Rivera.
Good morning.
Mr. Rivera, you are charged with home invasion with a firearm or other deadly weapon in count 1, and in count 2, burglary with assault or battery. I'm going to find probable cause.
Judge, I would like to briefly address the probable cause.
Okay, go ahead,
If I
counsel.
may. Judge, he's listed with a robbery, a home invasion with a robbery or other deadly weapon. The actual probable cause affidavit that the officer filled out, to my best of my knowledge, doesn't even indicate what weapon he carried. Did he carry a weapon? There's no real indication. Frankly, the actual probable cause affidavit, especially on 2 light felonies, is about as bare bones as you can get. I know the state was going to be asking for a proof evident presumption great to be found. I can tell the court from my reading of this, there's no way that there's proof evident presumption great by what the officers put in the probable cause affidavit. And I would argue even against probable cause for the Berg bat, as he's listed, not as Mr. Rivera is not actually listed as having hit anyone, but merely in the presence while someone else attacked the victim. And again, the home invasion robbery, there's no allegation of a knife, a gun, any type of weapon involved. But with that being said, one of the issues, Judge, is I don't necessarily want to have the state ask for 24 to 48 hours to perfect the probable cause. So I would say we would agree to the probable cause on the counts if we could agree to like a level 1 pretrial release with a GPS monitor. His mother is present in the courtroom, and he would be staying with her if he was granted that opportunity. He doesn't have any prior history. He is 25 years old, and there are some other underlying issues that Mr. Rivera has that obviously I don't want to address necessarily publicly, but I did, if the court wants to do sidebar or something like that, I could bring to your attention, but that's kind of where we're at right now.
State.
Yes, Your Honor. The state would be requesting, in addition to probable cause, proof evident presumption great. This is a punishable by life felony. On the probable cause affidavit, it does indicate that he did enter the home of the victim with a deadly weapon, at which point the victim was struck. And for that reason, Your Honor, the state is requesting proof evident presumption great. And
Where in the probable cause affidavit does it mention the deadly weapon?
it states on the second line, Your Honor, the defendant,
It
Alex
says
Rivera,
it did commit robbery with a deadly weapon.
by entering the victim's home with the intent to commit a robbery and was an accomplice to stealing the victim's cell phone and $120 in cash. The defendant was present at the time when the accomplice attacked the victim. The defendant did enter the victim's home without the invitation of the victim.
Right, and it goes on in the second page to talk about other things, but once it says he committed this crime by, it's really what comes after the by language that I look for probable cause, and I don't see a reference after he committed this specific crime by, I don't see any reference to a weapon. You see what I'm saying?
Yes, Your Honor. The state
How is that insufficient probable cause? Certainly for the weapon part of the,
Judge, while here it does not mention the actual specific weapon, it does indicate that it was a deadly weapon, and that's
where?
On the second line, it says with a deadly weapon.
No, I know, it says committed the crime of with a deadly weapon, but it doesn't mention any facts that would support that crime or that allegation. See what I'm saying?
Yes, Judge.
So I'm going to find the affidavit insufficient concerning the allegation, the probable cause insufficient to support the allegation of with a deadly weapon.
Judge.
Do you have any request?
Yes, Your Honor. The state does request a 48-hour to perfect.
And Judge, just with that being said, I would ask the court to find probable cause as to a robbery as to count 1, because again, one of the issues, Judge, is some of the underlying issues that Mr. Rivera has, and the reason why his mother's here today. And that's why we ideally don't want to have him sit for 48 hours. And like I said, this type of probable cause on 2 light felonies that he's accused of, 2 paragraphs, is as bad as bare bones that you can possibly get. But again, I'm not necessarily here to disagree with anything. I just would ask the court to find probable cause on burglary and a robbery, and give him a bond, but preferably a pretrial release, level 1 with the GPS. And again, if the state decides, based on more information, to file the armed home invasion and a burglary with a battery, they can address a no bond hold at the time of filing.
State, what is your, and I'm inclined to give it the time that you want, but what is your response to Mr. Hancock's request for interim
Your Honor,
release?
The state still requests the 48 hours to perfect, to be able to have the probable cause for the home invasion with a firearm or deadly weapon, as well as the burglary with assault or battery. That's what the state's requesting.
And nothing about the release in the interim?
Well, Your Honor, in the interim, the state requests for that time to be able to perfect, to then argue again, prove evidence of something great, to be able to hold him no bond.
Yeah, Mr. Hancock, I think they're right. I'm gonna have to, I'm gonna give the state 48 hours to perfect.
At least do 24 hours, Judge, so I can be back tomorrow. I mean, I understand they're entitled to 48, but we can get this done in 24 because.
State, is that possible? You can,
I'm not sure, Judge, given the surrounding circumstances.
yeah, Mr. Hancock, I think, given what we're going through right now, ordinarily, and I understand your advocacy on behalf of your client, that's right. And you're making a reasonable request. Unfortunately, under these circumstances, I don't know
Okay.
that it can be accomplished. So what I'm gonna do,
And the only last thing, Judge, I don't mean to
hold
interrupt.
on, what I'm gonna do is I'm going to, and this is a little bit unusual, I'm gonna grant you the 48 hours, but I'm gonna reset it for tomorrow.
Yes, Judge.
To see whether, and I'm gonna ask the state to attempt
Yes, Judge.
to get whatever you need to do to perfect it, done by tomorrow.
Yes, Judge.
So that, Mr. Hancock, if it's possible, if the state's able to do it, you can have your hearing tomorrow on this issue. If it's not, well, then we'll go to the 48 hours, then we'll have to reset it again tomorrow. I hate, it seems like the inefficiency of that, but I understand,
Judge. I
I understand the argument that you're making, and I find it reasonable. Everybody okay? So we'll reset this for, I'll give you, the state will get its 48 hours to perfect, or to add, and include the description of a deadly weapon, if there is probable cause for such a description. And I will, but I will set it on for tomorrow, just in case you can do it sooner than that. And I ask that you try. Thank you, folks.
All right, thank you, Judge.
And ladies in the audience, thank you very much for coming. I appreciate you being here, and I thank you for your support. Do I write on here? I sign it?
Yeah, you said.
You understand what I'm doing?
You said it for the month, but you didn't say for the
Yeah. All right, folks, let's go to the top of the docket. Start with Amber Hill, or D. Amber Hill.
Good morning.
No, I think it's North Broward.
North Broward? All right. Ms. Hill, good morning. How are you?
Good morning, how are you?
Good to see you.
I could be better, thank you.
I understand. Ma'am, you've been charged with 2 counts. One count is a count for touch or strike battery in a domestic violence situation, and second is a count for touch or strike battery. I'm going to find probable cause for those offenses, and I'll hear from counsel on bond. State?
Yes, Your Honor, the state does request a $1,000 bond on each count, as well as no victim contact and no return to the scene.
So you can't hear.
I'm sorry, I can't hear you.
Could you speak up?
Yes, Your Honor, the state does request a $1,000 bond on each count, as well as a no victim contact order, as well as a no return order.
Defense?
I'm gonna be asking for an ROI in this case. Let me explain. She has 2 kids, 5 and 8. They both live in the house. This whole thing started with a confrontation, just so you know, between her and another guy. She do something, and what she do hit a girlfriend. She was defending herself. In fact, Judge, just for the record, the other guy pulled a gun on her, but he had a gun permit. He slammed her, threw her against the wall, and when she threw the thing that she threw, it missed him and hit the girlfriend. And that's the reason she was arrested. Her and the girlfriend lived together. She can't afford bond. So what I'll be asking for is that you ROR her, put on an electronic monitor. I have some concerns about the no contact order because the fight was not between her and the girlfriend. The fight was between her and somebody else. So, to place her a no contact order at this time when the fight was not between her and the girlfriend, I have some concerns about that. And I don't know where she's going to stay. She is from Georgia, and I don't want her kids to end up in DCFS. Right now, she does not have the funds. So what I'd be asking for the court to do is release her. If you release her with a electronic monitor, she has to have a home address. She can use the home address that she has now, and she can call into probation. And if there's a problem with the address, I think we should come back to court and address that. But to hold her on this, given the circumstances in this case, and put a bond on her, I think would be quite unfair.
State?
So,
Judge, the state has no further arguments. It stands by its previous request.
Okay. I'm gonna, on count one, I'm gonna issue order a $500 bond, on count two, a $500 bond, and I'm gonna order no harmful victim contact.
thank you, Your Honor.
Okay.
Ma'am, what that means is, I'm gonna release you on $500 bonds on each of the charges. I'm also gonna order that you not have any harmful contact with the victim, which means if you do anything that harms her,
Okay.
and the alleged victim, if you do anything that harms her, we're gonna readdress the status of your
Right,
pretrial
okay.
release. Do you understand that?
Yes.
Thank you, ma'am.
Now, excuse me, the $500 bond, I don't have the funds, so how would that work? I don't own any property, and I don't own a car, so how would that work, if you don't mind me asking?
Sure, you're gonna have to talk, that's something you ought to talk about with your lawyer. And if in fact, after trying, you're unable to do it, perhaps your lawyer could go back in front of the division judge and get him to reconsider, him or her to reconsider.
Okay,
Thank you, ma'am.
okay, thank you.
All right, next is Brijana Williams.
In jail.
Ms. Williams, how are you, ma'am? Good morning.
Good morning.
All right, ma'am, you are charged with touch or strike battery in a domestic violence situation. I'm gonna find that there is probable cause to support that allegation in the arrest paperwork, and I'll hear from counsel on pretrial release.
Yes, Your Honor. I will be requesting that she be ROR'd and placed on standard pretrial. If you see in the PC, this appears to be a verbal altercation between sisters that occurred at their aunt's house. Neither the victim or the alleged victim or the defendant live at the aunt's house. My understanding is the alleged victim lives in Georgia. It appears that there was a verbal argument, and at some point, the defendant allegedly struck her sister in the face. All of the witnesses refused to cooperate. Post Miranda, the defendant said she didn't remember hitting her sister because it all happened so fast. The alleged victim refused fire rescue and also said she does agree with pretrial release. So I would be asking, since she's going to be living with her mom, she's able to stay somewhere, she's not going to be able, she understands she's not going to have any contact with her sister in the interim, that we ROR her and put her on standard.
State.
Judge, the state is requesting a $500 bond on this charge, as well as a no victim contact order and no return. The state has concerns based on the facts of the probable cause affidavit.
All right, I'll issue a $5,000 bond and a no victim contact order.
Is it a $500?
I'm sorry, $500 bond, that's what I meant.
All right, thank you, Your Honor.
Okay, ma'am, what I'm gonna order is a $500 bond on your account, but I'm also gonna order that you not contact the alleged victim in this case until the case gets resolved. And what that means is literally no contact. I don't want you being in the same place at the same time as she is. I don't want you having any telephone contact, no texts, no no emails, no social media, no contact at all, either from yourself or through another person. Do you understand that?
Yes, sir.
Thank you, ma'am. All right, next is Brittany Brazil.
Good morning.
Good morning, ma'am.
Hello.
Okay, is Brazil, am I getting that right? Brazil?
Yes.
Morning, Miss Brazil, how are you?
Okay, could be doing better.
You are charged with battery that caused bodily injury in a domestic violence situation. Ma'am, I'm going to find there's probable cause stated in the affidavit, and I'm going to ask counsel for their comments on bond. State,
Your Honor, the state is requesting a $500 bond on this case as well as a no victim contact order and no return.
defense?
No objection.
All right, then I'll order that. So I'm going to order a $500 bond, no victim contact, and no return to the alleged scene.
Will it be okay if my boyfriend can be able to pick up my belongings? Because I do have two children and all of their stuff is still over at my aunt's house.
Yeah, ma'am, what you can do is you can get together with law enforcement for one trip back to the place so you can retrieve, whatever you need to retrieve during the period of this. So you need to talk to your lawyer about how to.
If she's not doing it herself and her boyfriend is doing it, then she
Yeah.
doesn't need law enforcement.
If you
But
want to send your boyfriend, you can do that. But if you want to go get it yourself, you've got that opportunity.
I
Okay,
don't want to.
all righty. All right, ma'am, let me talk to you about no victim contact. And like you've heard me tell some of the other people here today, it means exactly what it says, no victim contact at all. So it means you cannot be in the same place at the same time as the alleged victim in this case. You can't contact her in any way, including by phone. You can't call, you can't text, you can't email, you can't do any social media contacts, and you can't even contact her through another person. Do you understand that, ma'am?
Yes, sir.
Thank you so much.
Thank you.
Good luck to you.
Thank you.
All right, next is Angelina Jones-Fox.
Yes, sir.
Good morning, ma'am. How are you?
I could be better.
Good to see you. Ma'am, you are charged with DUI, alcohol or drugs, second offense, and reckless driving, first offense. I'm going to find that the affidavit states probable cause, and I'll hear from counsel on the bond.
State requests standard bond, Judge.
Standard, and how much is that?
It's 1,000.
And what about on count two?
Count two, it's fine at 0.
Excuse me?
It's fine with no bond.
Okay. Not no bond,
With no bond amount.
with a
$0 bond.
$0 bond.
No, two is what?
He is fine with a $0 bond, functional of an RR, I
Okay.
guess.
So Miss Davy lives in Florida. She's been living here for,
Ms. Jones-Fox?
I'm sorry,
Yes, sir.
Miss Joan Fox.
Okay, go ahead. And could you speak into the microphone, please?
Yes, sir.
Thank you.
Miss
I
Jo-
want your client to be able to hear you.
Miss Joan Fox lives in Florida. She's married. Right now, she has no funds, and what we'd be requesting is that the court ROR her with an electronic monitor. Also, Judge, if the court is going to impose a bond, I would be asking for an ROR first. But if the court is going to impose a bond, she has no way of contacting anyone to get funding to even try to bond out, which to me would be tantamount to no bond at all. So she does have a cell phone. What I would ask is that she be allowed access to her cell phone so she could make some phone calls if the court is not inclined to ROR her, so she can at least try to get someone to post bond. She's not a risk to flee. She does have ties to the community. She does have kids who she's raised. and she understands that this is a second DUI and she's not to drive. The car currently is impounded, so I don't think that would be a problem. So that's why I'm asking the court for an RR as opposed to a bond.
All right, I will issue a $1,000 bond on count one, an ROR on count two, and I will agree with Mr. Ramillies, his request that Ms. Jones Fox shall be allowed access to her phone so that she can contact persons in connection with her bond. Any other conditions, State?
Nothing to say, Judge.
Anything further from the defense?
Would the court consider a little lower bond so she can at least try to bond out? I mean, the only reason I'm asking that in this case is because I understand the reason for setting the bond, but money is a problem for her at this time.
I'm going to keep it at 1,000, but thank you for your offer. All right, next is, and ma'am, good luck to you, ma'am.
Thank you.
You're welcome.
So give me my phone, I guess, in here, my property.
Yeah, they will give you your phone. They should give you
So what-
access to your phone.
Access to your phone. What I'm ordering is you should get access to your phone for the purpose of contacting people in connection with raising your bond.
So what they will
Okay.
do, they will give you access to the phone numbers in your phone. You will be able to go on your phone and get the phone numbers. You will not be able to use the cell phone in jail, and you should be able to make a call from jail to someone to assist you.
But if I have to call the bank to just have the debits transferred to, who do I transfer those to?
I can't help you with that. You will have to speak to the jail about that.
Okay,
Anyway, thank you, ma'am.
thank you.
Next is Jacqueline Delgado.
She does require the Spanish interpreter. She's at Maine.
Okay. Good morning, ma'am.
Buenos días, señora.
Okay, Mr. Interpreter, could you please raise your right hand? Do you solemnly swear to translate from English to Spanish and Spanish to English to the best of your ability?
I do.
Tell
Zachary
us your name.
Shapiro. Shapiro.
Thank you, ma'am. Good morning, ma'am.
Buenos días, señora.
Buenos días.
Good morning.
You have been charged with a violation of felony probation.
Usted la han acusado de haber quebrantado su probatoria por un delito grave.
State?
Yes, Your Honor,
Fiscalía.
the state, requests that the bond stays at no bond and defers to the division judge.
La fiscalía va a pedir que no le den fianza, como ya lo habían fijado antes, y que permitan que el juez original del caso se encargue de abordar el tema.
Defense?
Your Honor, had I
Defense.
not spoken with Ms. Delgado this morning, I wouldn't have necessarily had a great argument to present to Your Honor. However, she did advise that she was recently discharged from federal prison after serving 2 years. on the
Señoría, si yo no
19
hubiera hablado con la fiscalía, con la acusada esta mañana, no me hubiera opuesto al argumento de la fiscalía, pero esta mañana hablé con ella y me enteré que la liberaron hace poco de una pena de prisión que estaba pasando de 2 años.
Ms. Chambers, give him a little time to catch
Sorry,
up.
I
That's
forgot.
okay.
So it appears that the allegation was absconding from 2016. However, if she was picked up and placed in federal prison, that was not a willful act.
Parece que los alegatos fueron de fugarse de la supervisión en el año 2016, pero si la arrestaron por un delito federal, no es un quebrantamiento voluntario.
So it appears that she did not willfully violate her probation, but she was picked up on federal charges.
Así que aparenta que no quebrantó su probatoria voluntariamente, sino que la arrestaron por cargos federales.
I read the affidavit to have that alleged allegation of absconding to be the new violation, but I see that there are other prior violations that are new law violations. Am I right?
Después de haber leído la denuncia, usted pensó que obviamente ese acto de haberse fugado era un quebrantamiento original, pero veo que hay quebrantamientos previos. ¿Verdad?
From 2016, Your Honor, I don't know if those had anything to do with her prison sentence or if they've been resolved.
Son el 2016, no sé si eso tiene que ver con su pena de prisión o si ya se habían resuelto.
I would just ask, and she has no family here, but she does live in Miami and Hialeah. She has no access to funds. I would ask that we just place her on level 1.
Ella
and ROR.
vive en Miami, en Hialeah, no tiene familia aquí, por eso le pido que la pongan en libertad supervisada de nivel 1 y que la liberen bajo palabra.
I thank you for your arguments, but I'm going to keep it as a no bond. And if need be, you can take these issues up with the division judge.
Sí entiendo sus argumentos, pero aún así no le puedo dar fianza y ella puede lidiar con ese tema después con el juez encargado en la división.
Thank you, ma'am, and good luck to you.
Gracias, señora, y buena suerte.
Okay, next is Naisha Jacroy.
She's in
Major, Your Honor.
Come on up, Ms. Jacroy. And is that Jay Croy?
Yes.
Okay. Good morning. How are you? All right, you are charged with burglary of an unoccupied conveyance unarmed. And I will find that there's probable cause for that allegation. And I'll hear from counsel concerning bond.
Your Honor, I spoke with Mr. Croyce. She's currently does not work. She's very young. I believe she's 19 or 20 years old. She's currently homeless, doesn't have any family support here, but she can stay at a friend's house. She did advise me when she's not at her friend's house, she does live and stay in the area of Sunrise. I would be asking that the court put her on level 2 pretrial since she does have an address, and ROR her since she has no ability to post any bond and would otherwise have no friends or family to post one on her behalf.
State.
Judge, I'm asking the court to impose a $3,000 bond. Looking at the defendant's priors, there is a open petty theft case in front of Judge Miller over in the South Satellite, and there's also a previous drop, grand theft auto, as well as a burglary. So the
Drop. You said that was dropped?
drop, Your Honor, yeah. The state is requesting a $300 bond.
And I just want to clarify, State, are those juvenile priors because of her age?
It's from 2018.
So might be.
Might not. All right, I'll place Ms. Jacroy on a level 2 pretrial release.
Thank you, Your Honor.
Next is Kiana Belletz
Medical loan, Your Honor.
on medical loan.
Yes, sir.
Okay, thank you. Next is Heather Parker.
See for her. Oh, did you?
She's a medical reset, Your Honor.
Heather Parker's a medical reset.
Yes, sir.
Thank you.
You're welcome.
I just want to advise the court I have allergies. That's why I'm sneezing.
I didn't even notice, which is something that's probably bad on my part.
It's the carpets.
Don't worry, I'm the first one getting it.
All right, next is Grace Sherry Cheryl Johnson
Medical loan, Your Honor.
on medical loan.
Yes, sir.
All right. Thank you. Next is Brian Abreu.
Major.
Good morning, sir. How are you?
Good morning.
Is that the correct way to pronounce your name? Abreu?
Abreu.
Abreu.
Yes.
Nice to meet you, sir.
Nice to meet you.
You are charged with touch or strike battery in a domestic violence situation. I will hear from the parties on probable cause.
State, do you want to go first, or would you like
State?
me to go first?
Yes, Your Honor, the state is requesting a $500 bond.
No, we're starting with probable cause.
Oh, I'm sorry, Your Honor. Your Honor, the state is requesting that you find probable cause on this offense, based on probable cause affidavit.
Sure, go ahead. Thank you.
Honor, the probable cause affidavit does indicate that the defendant pushed the alleged victim, and there is a witness that indicated that she observed scrapes and injuries on the victim.
And what were those observed scrapes and injuries?
There was a small cut behind her left earlobe with fresh dried blood on her neck. According to the probable cause, it does indicate that the defendant and the victim were in a relationship together. This is a domestic violence battery. So the state asked the court to find probable cause as to the alleged offense.
Defense?
Your Honor, I would state that there's no probable cause. It doesn't appear that there's any intentional acts here on the defendant's part. It appears that the defendant and his girlfriend were at a friend's house and that everybody was drinking, hanging out, and that there was an issue with the defendant playing with the dog. I guess the dog started to get agitated, and two of the male members of the party wanted to remove him, and it appears physically, possibly forcibly, from the house. And that while that was going on, it escalated the situation, and there became some sort of issue between the defendant and those two gentlemen, and that the girlfriend approached while all of this was going on. And, you know, it appears, even from her own statement, that she thinks he accidentally pushed her, but does not remember exactly what happened. The PC says there's a small cut behind her left earlobe. It doesn't appear, even from the witnesses, that there was any intentional pushing by the defendant against the girlfriend. It does appear that there was some sort of physical act going on between him and other male individuals, and that he was actually pushed to the ground and injured himself. It appears that she just got in the middle of a tussle between these other individuals and was, accidentally knocked down. It doesn't appear that there's any intentional conduct here. And so I would ask that the court not find probable cause for a battery, which requires intentional touching, and especially domestic violence, because there's no violence here. It appears that this was just something that occurred in the middle of an altercation between other people.
Anything further from the state?
Yes, Your Honor. There is on the last page of the probable cause affidavit, on the first paragraph, it states that a witness gave the same account of the incident, and she said that she saw the defendant hit the victim in the ear with his right hand. It's the state's position that that would be sufficient to establish probable cause as to an intentional hitting on the victim, and the state does request that the court finds probable cause.
If I may just briefly respond.
Shirley?
To that. Even if there's somebody who says that they observed him, swinging at her, there's no proof or evidence here that anything was intentionally done. Again, we're talking about three grown men, everyone who's at least mildly intoxicated, forcibly, pushing back and forth, trying to get somebody out of the property and having their own issue, and then a woman coming and putting herself in the middle of the incident. Sometimes things happen unintentionally. We don't have any proof that he intended to hit his girlfriend.
State, I'm gonna agree with the defense on this. I don't see I don't see probable cause as alleged against this victim.
Yes, Judge. The state would ask for 48 hours to perfect.
Okay.
Your Honor, I would ask that he be released ROR in the meantime. Again, due to everything that's going on, it might take longer than that, and he can stay at a residence. We can put him on a GPS if the state wants, to make sure that they know where he is. It doesn't appear that he's someone who would be a flight risk. He's self-employed, and he lives in Miami, and he does have family here who he can stay with if they want him to stay somewhere else.
State?
State would defer the court on that, Your Honor.
Yeah, I will release some ROR in the meantime.
Does the state have 48 hours to perfect, Your Honor?
Yes, 48 hours to perfect, if you're able.
In the meantime, Your Honor, can the court issue a no victim contact order?
There's no probable cause for that, Your Honor.
I don't think that would be appropriate, given the determination that, as far as I can see it right now, based on the allegations and all reasonable inferences from the allegations, I don't see a probable cause. All right, let me check with the clerk about how to fill this out. Put this in here? All right, next, Juan Rivera Vieira.
Your Honor, he does also need the Spanish interpreter.
Great. Sir, could you raise your right hand? I know I already swore you in, but I'm going to swear you in again on the record this time.
Understood.
Do you solemnly swear to translate from English to Spanish and Spanish to English to the best of your ability?
I do.
Your name again, sir.
Zachary Shapiro, Shapiro.
Thank you so much. And Mr. Rivera Vieira, good morning, sir.
Señor Rivera Viera, buenos días.
Buenas. Sir, you're being charged with touch or strike, battery, and domestic violence, and 2 capiases on traffic offenses.
Usted lo han acusado de agresión doméstica por medio de golpear o tocar y también tiene 2 órdenes de arresto por delitos de tránsito.
I'm going to find probable cause
Hallo
for the
que,
touch or strike, battery, and domestic violence.
hallo que sea motivo fundado para el primer cargo de agresión doméstica por haber tocado o golpeado
And I'll hear from counsel on the issue of bond.
y escucharé la opinión de los abogados para determinar la fianza.
Your Honor, the state requests a $500 bond on count 1, as well as no victim contact and no return to place of incident.
La fiscalía va a pedir una fianza de $500 y al igual que una orden de no contacto con la víctima y que no le permitan regresar al lugar de los hechos.
As for the capias charges, Your Honor, the previous amount was $1,500. The state requests that the court maintains that amount.
Y en cuanto a los cargos que tienen órdenes de arresto, la fianza antes estaba fijada en $1,500. La fiscalía va a pedir que permanezcan esas cantidades.
Your Honor, had I not spoken with Mr. Rivera Vieira, I would believe that the state's request for bond of $500 on count 1 would be reasonable.
Señoría, si yo no hubiera hablado con el señor Rivera Viera esta mañana, pensaría que la petición de la fiscalía de dejar la fianza en $500 sería razonable. Sin embargo,
However, he is entitled to a bond that is reasonable and in accordance with his financial means.
él tiene el derecho a una fianza razonable y que le corresponde a sus recursos.
And he did advise that he cannot afford any monetary bond at this time.
Él me informó que no tiene los recursos para pagar una fianza monetaria.
He's been a resident of Broward County for 10 years and is not a flight risk.
Es residente de este condado por 10 años y no es un riesgo de fuga.
I would ask that the court place him on level 2 and issue no harmful contact order between him and his wife.
Por eso le pido al juez que lo pongan en libertad supervisada nivel 2 y que emita una orden de no contacto violento con su esposa.
It does look like this is an incident stemming from intoxication, so maybe we can also put a no alcohol or intoxicant order in place as well.
Parece que este incidente surgió a causa de la embriaguez, entonces su señoría también tendría la opción de ordenar que no consuma alcohol tampoco.
I don't believe he has anywhere else that he can go or stay at this time.
Porque creo que en este momento no tiene ningún otro lugar donde pueda quedarse.
Okay, I'm going to issue a $500 bond on count 1. I'm going to leave the traffic capias bonds as such.
Está bien, entonces fijaré una fianza de $500 para el primer
$1,500
cargo
each.
y dejaré los otros 2 cargos en $1,500 de fianza cada uno.
I'm going to order no victim contact,
Ordenaré no contacto con la víctima
no return to the scene,
y que no regrese a la escena de los hechos.
and
al
no
lugar de los
alcohol,
hechos.
drugs, or other intoxicants.
Y no le permito poseer ni consumir alcohol ni otras sustancias embriagantes.
Mr. Rivera Vieira, I've ordered that you not have any contact with the victim,
Señor Rivera Viera, he ordenado que usted no tenga ningún tipo de contacto con la víctima.
and that means no contact of any kind.
Eso quiere decir que no puede comunicarse con ella de ninguna manera.
That means you can't be in the same place at the same time that she is.
Quiere decir que no puede estar en el mismo lugar, al mismo momento que ella esté presente.
You can't directly contact her by telephone, text, video, any other means.
No puede comunicarse con ella por mensaje de texto, llamadas, videos, ni por ningún otro medio.
Electronic or otherwise,
Ningún medio electrónico o algún otro tipo de comunicación.
and you can't have anybody else contact her on your behalf.
Y usted no lo puede pedir a un tercero que se comunique con
Do you,
ella.
do you understand that?
¿Entiende eso? Yes.
Sí.
Yes.
Thank you so much, sir. All
Muchas gracias, señor.
right, next is Jorge Robaina.
And I believe this is senior. There's 2 on the docket.
Right, this is Jorge L. Robaina, and this is Mr. Robaina Sr. Good morning, sir. How are you?
Buenos días, señor. ¿Cómo está?
Buenos días.
Good morning.
Okay, and once again, Mr. Interpreter, could you tell us your name?
Zachary Shapiro, Shapiro.
And you've previously been sworn in.
Yes, sir.
Mr. Robaina, you are charged with touch or strike battery domestic violence.
Señor Robaina, a usted le han acusado de agresión doméstica al golpear o tocar.
And I'll hear from the parties on probable cause.
Y escucharé la opinión de las partes con respecto al motivo fundado.
State?
Fiscalía.
Yes, Your Honor. The state requests that the court finds probable cause on this case. The probable cause indicates that the defendant, along with the co-defendant, Jorge Robina Jr., struck the victim on the side of the head.
Sí, la Fiscalía va a pedir que usted haya motivo fundado en este caso porque según la denuncia, el acusado, el señor Robaina, y el coacusado, el señor Robaina, dijo que él golpeó a la víctima en la cabeza con la mano.
Any further, State?
¿Algo más, Fiscalía?
One moment, Judge.
Okay.
Un momento, juez. Está bien.
Judge, there's further information from a witness who's the wife of the defendant as well as the mother of the co-defendant.
Tenemos más información de la esposa del acusado y es la madre del coacusado.
That the defendant and the co-defendant were engaged in a fight and they were pushing each other.
Dijo que el acusado y el coacusado estaban peleando y se estaban empujando entre sí.
And it escalated to the point when they struck each other inside the head.
Y eso llegó hasta el punto que se golpearon en la cabeza. Y por eso pedimos que usted haya que si hay motivo fundado.
Defense?
Defensa.
Your Honor, as to the father, George Robaina, who we're addressing at this time, I don't believe that there is probable cause for domestic violence battery.
Bueno, con respecto al padre, el señor Jorge Luis Robaina, el caso que tenemos presente ante nosotros en este momento, creo que no hay motivo fundado para el cargo de agresión doméstica por golpear o tocar.
As to the taxi driver, who I guess is the person who called the police, we have no understanding of how he allegedly observed two people inside of a house.
Y con respecto al taxista, que supuestamente fue el que llamó a la policía, no sabemos exactamente cómo fue que él observó a dos personas luchando dentro de su propia casa.
Also, we have the mother who states that it was the son, George Robaina Jr., who came home and appeared intoxicated, requested money, and that the defendant refused to provide him money.
También tenemos a la señora, a la madre, quien dice que el hijo fue el que llegó a la casa y aparentaba estar ebrio y que les pidió dinero y que el acusado se negó a darle dinero.
And that the son started to smash objects in the residence and pushed Mr. Robaina, the defendant, onto the floor.
Y que el hijo empezó a romper artículos dentro de la casa y que el hijo fue el que empujó al señor Robaina, padre, al piso.
There's no probable cause as to Mr. Robaina hitting the son in this case. It does appear that there was some issues involving the police.
No hay motivo fundado para creer que el señor Robaina fue el que golpeó a su hijo en la cabeza. Pero sí hay
Right.
ciertas declaraciones por parte de la policía, pero
But there's nothing that shows that he actually did any intentional touching towards his son.
esto no demuestra que él haya intencionalmente golpeado o tocado a su hijo.
All right, I'm going to find, I'll find probable cause.
Sí hay motivo fundado.
Let's address appropriate conditions of release.
Ahora abordaremos el tema de las condiciones de libertad.
A $500 bond as well as no victim contact.
La fiscalía va a pedir una fianza de $500, al igual que una orden de no contacto con el coacusado.
Defense?
Defensa.
Your Honor, I would not object to the $500 bond. However, I would ask for no harmful contact order with the son.
Pues yo no me pongo a la fianza de $500, pero sí le pediría que la orden de no contacto con el hijo sea una orden de no contacto violento.
It appears that this is the defendant's residence, and so if anybody would be asked to leave, it would be the son,
Parece
but
que esta es la residencia del acusado, así que si van a pedirle a alguien que
Yeah,
salga de la
the state
residencia
has
debe
not,
ser el hijo.
the state has not asked for a no return.
La fiscalía no pidió esa condición de no regreso.
Okay, I'm going to issue a $500 bond in this matter. I'm going to ask Mr. Robaina Senior to have no contact with the alleged victim in the case.
Fijaré una
And I'm
fianza de
also going to
$500
order no alcohol, drugs, or intoxicants.
y emite una orden de no contacto con respecto a su hijo y también ordena que no posea ni consuma drogas ni sustancias embriagantes.
Mr. Robaino, I'm going to ask that you have no, I'm going to order that you have no contact with the alleged victim in this case.
Señor Robaina,
And by no
voy a-
contact, that means no contact whatsoever.
Voy a ordenar que usted no tenga ningún tipo de contacto con el coacusado en este caso. Y eso quiere decir que no puede tener contacto con él de ninguna manera.
And what that means is you can't be in the same place at the same time as he is.
Quiere decir que usted no puede estar en el mismo lugar al mismo tiempo que él.
You can't contact him directly by telephone, text, email, video, any way.
Y no se puede comunicar con él por mensaje de texto, teléfono, correo electrónico o video, ni por ninguna manera.
And you can't have anyone else contact him on your behalf.
Y usted tampoco le puede pedir a un tercero que se comunique con él de parte suya.
Do you understand that?
¿Entiende eso?
Está bien.
That's fine.
Thank you, sir.
Gracias, señor.
Good to see you.
Gracias.
If I may?
You may.
Yeah, thank you very much. I know you already made your decision. Here's what's troubling me about this probable cause affidavit, is that you have a son who goes to a parent's house and demands money, and the father says to the son, "You're a grown," and it's in the arrest affidavit. Go ahead.
Señoría, ese es el problema que yo veo aquí, si usted me permite. Es un problema con la denuncia. Dice aquí que el hijo fue a la casa de sus padres a pedirles dinero
Grown man,
y ellos le dijeron que tiene que conseguir trabajo porque es un hombre adulto
and that he wasn't going to give him any money.
y que no le iba a dar más dinero.
I just, you know, I understand that you have already set the bond at $500, but
Así que yo entiendo
this
que
thing
usted ya tomó
started
su
out about
decisión
money,
y ya fijó
and
la
now we're
fianza en
going to make
$500.
him pay a bond for his son who goes to his house to literally try to get money.
Pero en este caso se trata del
Will the
dinero.
court consider
¿Cómo le vamos a pedir que pague $500 de fianza?
ROI him, putting him on an electronic monitor? The court can give him any other stuff, but I think to put a monetary bond upon him trying to get his son to be a grown man and standing his ground in his house, I don't see probable cause here.
Creo que no hay motivo fundado y no es justo imponer una fianza monetaria cuando fue el hijo el que fue a su casa a pedirle dinero. Creo que debemos ponerlo en darle libertad bajo palabra, ponerle un monitor para poder liberarlo.
And Mr. Ramillis, had Mr. Robaina stopped it at the fatherly admonitions,
Si el señor Robina hubiera parado en el punto en que ya le había dado el regaño necesario a su hijo como padre,
we wouldn't have this issue.
no hubiéramos tenido este problema.
And if you believe that there is an affirmative defense to be raised here,
Si usted cree que hay una defensa positiva que
then,
usted pueda
then certainly
ejercer,
by all means, but that's for later proceedings.
lo puede hacer en el futuro, en el procedimiento siguiente.
Okay, thank you, sir. Thank you for
Bueno,
coming
ya,
back,
gracias,
and thank you,
señor.
sir. Your lawyer
Gracias por haber
continued to
regresado.
advocate on your behalf.
Su abogado siguió argumentando a su favor.
All right, Michael Watts.
Mandrill?
Good morning, Mr. Watts. How are you?
Good morning, Your Honor. How are you?
Good. All right, sir, you are charged with battery on a person 65 years of age or older. I'm going to find probable cause based on the documents that were submitted, and I'll hear from counsel on bond issues. State.
Yes, Your Honor. Looking at the defendant's priors, he does have a prior grand theft from 2019, as well as a resisting without violence in 2019, and a trespass in 2019.
the defendant is 18 years old.
In addition, Your Honor, pretrial supervision, the defendant is currently out on a domestic battery, case number 20001685 MM10A. He's on pretrial supervision, GPS level 2. At this time, we're requesting a revocation of his supervision based on the new law violation.
Defense?
Your Honor, I spoke with Mr. Watts, and he is a young 18-year-old gentleman. He was residing with his grandfather, who is the alleged victim in this case. The allegations are that he struck him on the kneecap with a screwdriver. While these aren't the greatest acts, they don't appear to be extreme or extremely dangerous acts. And there's really no context as to how this occurred. He did advise that he was just recently released from DCF custody. So there are issues with the family in and of itself. His mother is the one that's in possession of all of his financial abilities, and he advised that she suffers from substance abuse and addiction, and so he wouldn't even really have faith that she would post a bond with his possessions on his behalf. He is young. Given everything that's going on, I would ask that the court allow him to be released on level 1, and that the defense is allowed to find him a housing situation in the meantime. So maybe we can place this on for tomorrow, so that we have time to find him housing, but we can put him on level 1 in the meantime.
State?
Your Honor, based on his priors and the fact that, based on the allegations from pretrial, the state is going to be requesting a $2,000 bond on this current charge.
And pretrial, remind me, what were the conditions of pretrial release that Mr. Watts was on before these allegations?
He was on pretrial GPS level 2. He was released from, this order was written and dated February 28th, 2020, and he was to have no contact with the alleged victim.
All right, anything further from the defense? Oh.
Actually, he's been out of custody probably approximately.
Anything further from the defense?
No, Your Honor.
The state would also ask for a no victim contact order as well as a no return.
All right, I'm going to issue a $5,000 bond, in this case, with a no victim return, and I'm going to issue a bond of $5,000 on the pretrial services revocation.
Thank you, Your Honor.
Mr. Watts, I issued bonds on both of your cases. In this case that you're here on the first appearance with me today, I'm going to issue a $5,000 bond in that case, and I'm going to add that you're not to have any contact with the alleged victim in the case. And by that, that means no contact whatsoever. That means you can't be in the same place at the same time as that person. You cannot contact them directly through phone or text or email or any other way, and you can't contact them through third persons. All right? You keep raising your hands. If you'd like to say something, I'm happy to hear anything you have to say that would concern the bond issue. But I advise you once again, kind of like I did to everybody in the beginning, don't say it. It's not a good idea for you to say anything about the facts of this case, because everything we say here is being recorded, okay?
Well, yes, Your Honor, I understand. The thing is, Your Honor, with my grandfather, he has dementia.
Sir, it's probably not, I mean, I don't want to cut you off, and I don't want to prohibit you.
Well, I'm not going to talk about the case or anything that will, be used against me in a court of law. It's just with the no contact. The thing is, with my grandfather, he has dementia, and his wife just passed away, and he is on his own. So when I was staying there with him at his house, I was helping him out financially with his taxes and stuff like that. Because due to my grandmother passing away, he had to get ashes made for her, and a lot of his finances went to that. And he had just bought me a car recently. So he's basically kind of broke. He doesn't have any money. He's just living off his monthly disability check. So when I was staying there with him, I was helping him out financially. He can prove to that I was giving him money on a daily or weekly basis to help him out with his needs, because he goes shopping. He goes out to eat every day, Boston Market. He has a scheduled routine, and he doesn't have funds to keep on maintaining to his needs. and if I'm gone and if I can't have no contact. So is there any chance that I could get a no harmful contact plea? Because all of this happened, he told me when I was getting arrested that he just wanted to teach me a lesson, and he wanted to teach me a lesson the hard way, and that this was for me to get my head together, being in here, to know that I shouldn't do what I do and I shouldn't react the way I react.
Sir, I'm
So I was
gonna,
hoping that,
yeah, Mr. Watts, I'm gonna stick with the current no contact order. As circumstances continue, and if in fact what you're saying continues to be an issue, your lawyer can always bring it up to the division judge that the case is assigned to. But for right now, I don't want you to have any contact with them, I'm sorry.
all right, and now, Your Honor, you had placed a bond at $5,000. Now the problem is, me just getting out of DCF custody. I've been in DCF since I was 13 years old. I have reported myself to go to DCF because my mother was a drug addict and I wasn't living the life I should have been living. I wanted to go to school, so when I went to DCF, they sent me to a program, and they just sent me to a program from the jump, the Grove Academy. It was supposed to be for substance, but I was not a bad kid at the age of 13. I didn't have any records of being bad. I was going to school. I had good grades and stuff like that. I was very responsible. And me going into the group home wasn't the best decision I think that I made to make that report, because ever since I entered the group home, I was surrounded by a lot of unruly people, unintelligent people, which led me to follow people and not set my own goals and, stuff to accomplish. So I followed after other people, which when I should have been leading myself. And I believe which all brought me here. So I don't have any family. Like I said, when I got arrested, the officers gave all my belongings to my mother, which I don't know why. And now she's just out with my car and stuff like that. So I don't have any friends that'll be able to bond me out with a $5,000 bond, because I believe at 10%, that'll be $500, Your Honor.
Yeah, Mr. Watts, I'm gonna make two observations. One is, I'm gonna keep the bond at $5,000 for now. Your counsel can always ask the division judge to reduce it, as circumstances kind of play out. Secondly, the observation is, you look like a very smart young man. Your record doesn't appear, or the allegations against you doesn't appear like you're living up to the smarts that you seem to be indicating to me that you have. I ask you to try and use those smarts that I think you just showed me you have in a positive way going forward. That's all I can say. So I wish you luck, sir. Thank you so much.
Thank you, Your Honor.
Okay, Jorge Luis Robaina. This is probably Mr. Robaina Jr. Good morning,
How you doing, sir?
Morning, Mr. Robaina. How are you?
Good morning, I'm fine, and you?
Good to see you. All right, sir, you are charged with touch or strike battery and domestic violence, resisting an officer, obstruct without violence, and a probation violation, a community control felony violation. I'm going to find probable cause for the first two counts, and I'll hear from counsel on bond.
Yes, Your Honor. Defendant does have priors. He does have a prior grand theft as well as a fraudulent use of a credit card. With that, Your Honor, based on the facts of the case, the state will be requesting a $2,000 bond on count 1, a $500 bond on count 2, as well as a no victim contact and no return.
Defense.
Your Honor, I spoke with Mr. Robaina, and he wanted me to inform the court as to count 3, the violation of probation or community control charge. He advised that he's been on probation for 7 years. This was the last year, and he actually was about to early terminate this month. Without getting into the actual facts, just based on the PC, this was a dispute with his father. He does have somewhere that he can stay that's not with his father, so there's no objection to the no contact and no return. And so I would just ask that, and I had no objection to the bonds that were requested on counts 1 and 2. I would just ask that the court sets a reasonable bond on count 3, or place him on pretrial level 2. The maximum amount of bond that he would be able to afford in total would be $8,000, just so the court's aware.
And what were the bonds that you had suggested again, counsel?
The state suggested $2,000 on count 1 and $1,000 on count 2. As for count 3, Your Honor, this is a Dade County VOP, the state would be asking that this remains as a no bond and have that taken care of with his division judge in Dade County.
Sorry, I thought the state said the first time 500.
That's what my notes say.
2,000 on count one and on count.
And 500 on count two.
Correct, that's what I had, Your Honor.
That's what I had too. That's what you've just said.
No, I misspoke right now. It's 2,000 on count one and 500 on count two.
Oh, okay, I'm sorry. That's what I had heard you say both times, so. All right, so I will order on count one, $2,000 bond, count two, $500 bond, but I'm gonna keep the no bond status for count three, and you all can take that up with the Dade County judge. I'm also gonna order no victim contact and no return to the scene. All right, Mr. Robey, what that means is, for the pendency of the case, I don't want you to have any contact at all with your father. I want, and by no contact at all, I mean, just like you've heard me tell this to so many other people today, you can't be in the same place at the same time as he is. You can't contact him directly by phone call or email or text or any other electronic or other means, and you can't have anybody else contact him on your behalf. Do you understand that?
Yes, I understand. Now, can I ask you a question?
You may.
Now, when you're saying that on count three on the probation violation, I have no bond, what that means I can't bond out then, right?
What that means is you're gonna have to go in front of the Dade County judge, and that judge will determine how you get out and what the circumstances are.
How would I be able, how do I get transferred from here to over there? Or how does that?
You're gonna have to talk to your lawyer about that, okay? I don't know the mechanisms for doing that, but, so talk to your lawyer about that, okay? All right, so Mr. Robino, good to see you.
Can I just answer?
Oh,
the
sure,
question?
Mr.
If you say, if you post the bond on the two cases that you have here, right? You listening?
Yes, I'm listening, sir.
Okay.
This is Mr. Ramillies, who is one of your lawyers.
If you post a bond in the two cases you have here, you'll be effectively released on bond in the two cases you have here. Then Dade County will come pick you up, and you can address your bond status in front of that court there, okay? You can essentially waive and go to Dade County and then come back and take care of these cases, all right?
Okay, but I'm gonna bond out first on those two
Yeah.
charges, and
Yeah.
then I'll go handle that.
Yeah,
okay.
yeah. You can just say that you want to be taken before Dade County. They will effectively come and get you. The public defender in Dade County will contact you.
Who do I have to speak that with?
Okay,
my
well,
private.
why don't you all do this offline? Well, thank you so much, Mr. Rabin, I appreciate it. All right, Michael Roman,
Main jail is approaching.
come on up, Mr. Roman. Good morning, sir. Is it Roman or Roman?
It all depends.
Okay.
I go by Roman, but the Latins call me Roman.
No, Roman is good. Sir, you are here on a misdemeanor capias. Any comments from either counsel?
Yes, Your Honor. I did speak with Mr. Roman, and he advised that this incident stems from him. He's currently homeless, but his friend has a vacant home where he's allowed to stay. And one of the neighbors saw him out front and called the police because they did not know that someone should be there. And that is how the police contact began, and that's where the capias issue stemmed from. But because he had permission to be there, there was no trespass or anything like that. So he was in a place where he was allowed to be. I would ask that the court release him on pretrial, and I would say standard pretrial. It's a driving while license suspended misdemeanor, being held no bond, especially in this circumstance when he has no financial ability to post a bond, just doesn't seem equitable.
State?
The state would be requesting a $500 bond on this capias. According to my notes, this does appear that the capias was issued for a no-show for a non-jury trial. So the state would request a $500 bond and have this dealt with his division judge.
Okay, I'm gonna issue a $100 bond on this matter. Thank you, folks. Thank you, Mr. Roman. James Franklin?
If I have
100.
Medical loan.
I'm sorry?
They advised
Medical
that he was
loan.
medical loan.
Medical loan. All right, next is Grover Willis.
Main jail, he's approaching.
Come on up, Mr. Willis. Good morning, sir. How are you?
Good morning, sir. How you doing? Fine.
Good to see you. Sir, you're charged with neglect of a child with great bodily harm, operating a motor vehicle with driver's license expired, and a misdemeanor capias. I'll issue, I'll find probable cause for the two allegations, and I'm willing to hear from counsel on bond.
Yes, Your Honor, I'm looking at his priors. He does have a prior resisting from 2013, possession of cocaine from 2017, resisting in a trespass from 2014, possession of PVP from 2017, a no valid DL from 2018, possession of PVP 2018, resisting 2018, and no valid from this year. The state will be requesting on count 1 a $3,000 bond, count 2 $500 bond, and count 3 the misdemeanor capias in the amount to remain the same of $750, as well as a condition for no alcohol, no intoxicants.
Your Honor, I have no objection to the no alcohol, no intoxicants. Based on the priors that were read, it does appear that there is some form of substance abuse or struggle, or at least a minimum use. I did speak with Mr. Willis. He is a permanent resident of Broward. He works here in Broward, but at the moment, all he can afford is $1,000. So I would ask that the court set the bond for count 1 at $1,000, and then on count 3, the misdemeanor capias. He advised that he was already served on this and released, and so I don't believe that he should have been arrested on the capias, and that there should be some reflection that he was already served in custody and released on this case.
I don't see any indication of that in the papers that I have, and I would expect you all to follow up on that, but I don't see that in the papers that I have. All right.
Your Honor, I'm sorry, Your Honor. Would Your Honor then consider RORing him on that, and then just placing the bond on count 1 at $1,000 and putting him on standard pretrial with no alcohol, no intoxicants?
No, what I'm going to do is I'm going to issue a bond of $1,500 on count 1, a bond of $500 on count 2. The bond on count 3 will be reduced to $100. And all of that with an order that there be no alcohol, drugs, or other intoxicants. All right, Mr. Willis, what I've done is I've set bonds for each of the charges that you're facing, but I've added an additional count, an additional condition based upon the circumstances of this case, that once you've bonded out, you not have any alcohol, drug, or other intoxicants the entire time you're on pretrial release. Do you understand that?
Yes, sir.
No alcohol, no drugs, no nothing, all right?
Yes.
Thank you, sir. I appreciate it. Good luck to you. Next is Stephen Wilsey.
Main jail.
How you doing?
Good morning, sir. How are you?
Good, how are you?
Good. Mr. Wilsey, you're charged with burglary of an unoccupied conveyance unarmed. I'm going to find probable cause on that offense based on the affidavits in the file, and reach out to counsel here to give me some comments on bond.
Yes, Your Honor, the state would be requesting a $2,000 bond on this charge.
It's a third-degree felony. I would ask that it be $1,000 bond. He is 18 years old. His family would be the ones posting on his behalf. He does not work at this time. He would be residing with his parents in Pompano, so I would ask that the court, in consideration of the fact that his family would be posting it, that it is a third-degree felony, and he is 18 years old with a residence, put the bond at $1,000.
All right, I'll issue a bond of $1,500. All right, Mr. Wilsey, good luck, sir. Next is Javon Ross.
Main jail, he's approaching, sir.
All right, Mr. Ross, you're also charged with burglary of an unoccupied conveyance unarmed. I'm going to find probable cause in this case based on the affidavit and paperwork, and hear from counsel on bond.
Judge, this is the co-defendant to the previous case. The state is requesting a $2,000 bond.
Defense?
Again, Your Honor, this is another 18-year-old individual whose father would be posting the bond on his behalf. He's currently in high school. He lives in Broward and he lives with his parents. I would ask again for a $1,000 bond.
And I'll issue a $1,500 bond for Mr. Ross as well. Thank you, sir. Good luck to you.
Thank you.
Thank you for your patience.
State, sorry, I don't know your name. Did you ever, never mind, actually.
Okay, Brian Etheridge.
Yes.
Good morning, sir. How are you?
Good morning. I'm doing good. How are you?
Good. Sir, you were charged with resisting an officer, obstruct without violence, and a probation violation of community control, felony probation violation. I'm going to hear from counsel on the probable cause. State?
Yes, Your Honor. In this case, Your Honor, the officer approached the defendant in his police uniform, as well as in a marked police vehicle. The officer gave verbal commands towards the defendant, and the defendant, in which case, did not comply, and he began to run away, and that's when the officer effectuated an arrest. The state asked the court to find probable cause for the resisting without violence.
Defense?
Your Honor, I would say that there's no probable cause. This is a very bare bones affidavit. It's just basically says that this officer responded to a disturbance call. We don't know what the disturbance call was about, what it was for. We don't know if it had any connection with the defendant. It just states that upon the officer's arrival, he saw the defendant knocking on the door at the address. There's no other information that anything unlawful or improper was going on, or that he was on a place where he was permitted to be. And it just states that he gave commands as he started walking towards him, but then Mr. Etheridge fled, he left. So I don't understand what the grounds were that he would have had to stay and respond to the police officer. I don't see any incidents that this is a high crime area, that there was any evidence of any other criminal activity. It appears that he had the right to disobey the officer and to leave if he wanted to do so.
State, respond to the last part.
Yes, Your Honor. The officer was dispatched to in reference to a disturbance. Once he arrived on scene, that's when he sees the defendant knocking on the door. He's dispatched for a disturbance of a residence.
But that's not what it says. It just says disturbance.
Yes, Judge. It's a reasonable inference from the probable cause affidavit that if the officer is dispatched for a disturbance, he is investigating a potential disturbance of a residence. He sees the defendant knocking on a door. He asked the defendant to come over. That was his verbal command. The defendant did not comply with that order, and at which point he begins to run away.
Yeah, I'm going to agree with the defense on this, that affidavit under those circumstances is really very bare bones. So I'm going to determine at this time no probable cause.
Your Honor, the state would request 48 hours to perfect.
Granted.
I was trying to get the violation of probation affidavit from the state. If the sole allegation of violation is count 1, I would ask that the court just dismiss the warrant at this time, and that the court allow Mr. Etheridge to be released, ROR, and put him on level 2 pretrial, so that way at least we know where he is if the state is able to perfect. He does have a permanent address where he can stay in Broward.
I'm going to give the state 48 hours, and then we can take it up at that time.
Okay, thank you.
Thank you so much. I'm not doing anything with it right now. The state's going to come back in. Thank you, Mr. Etheridge. All right, next is Amos Williams.
Main jail?
Okay, Mr. Williams, you're charged with burglary with an assault or battery. I'm going to find probable cause in this case. And I'll hear from counsel on the bond situation.
Your Honor, looking at his priors, he does have priors from 2016, felony battery, domestic strangulation, as well as 2 other counts of battery that he was adjudicated on, criminal mischief. He has a 2012 resisting an officer without violence. As for the bond, Your Honor, the state would be requesting a $7,500 bond.
Defense.
Yes, Your Honor, I'm reading the probable cause, and we have conflicting versions of what happened. Based on Mr. Amos's statements, he was the victim of a battery by his father. It appears that he was outside and that his father placed his hands around his neck in an aggressive manner. It then goes down to say that the father stated that they were in an argument over money and a job, and that the defendant tried to enter the residence, and that's why he put his hands on his son. However, it doesn't appear that there's any witnesses as to what actually took place. We just have conflicting stories. I don't believe that there is PC at this time. It also doesn't appear that there's any intent to commit a crime in the house. I don't see that listed here. Even based on the father's version of events, it just states that the defendant was trying to enter the residence. It doesn't say he was trying to enter the residence to do anything, particularly anything illegal.
What are your comments on bond?
Your Honor, I would ask that he be placed on level 2 pretrial release. He's unemployed. He recently lost his job. He does have a stable address. He's a 29-year resident of Broward.
Where is his stable address at the scene of the alleged offense?
No, he does not live with the victim, correct?
Correct. I live with my grandmother.
Okay. All right, I'm going to agree with the defense, a pretrial release with a level 2 monitor. And no contact with the alleged victim.
Okay.
Now, Mr. Williams, you probably heard me say this to everybody, a lot of other people before you, but I'm going to say it again to you just in case, okay? No contact with the victim means you can't be in the same place at the same time as that person. Literally, you can't be with them anywhere. Second, you can't have any direct contact with them. You can't talk to them by telephone, by email, by fax, by text, by anything. And third, you can't have anybody else contact them for you on your behalf. So no contact at all. Do you understand that, sir?
Understood.
Great. And I'm also going to order that you not go back to the scene of the alleged offense. Thank you, sir.
I have property there. Could I?
Yeah, what you can
could I
do.
retreat?
Yeah, what you can do, and your counsel can fill you in on this more. You can go to the property with law enforcement, with uniformed law enforcement, one time to pick up all your stuff and take it away, but only one time with law enforcement, so everybody can check, make sure everybody's acting like they're supposed to. And you can pick it up with one visit to get all your property at that time.
Thank you, Judge.
Or you can send someone to pick it up for you.
Or you can send someone to pick it up for you.
Thank you.
Thank you, sir. Next is Mark Perez.
Main jail?
Morning, Mr. Perez, how are you? This is a violation to fail to report, although I've got this as a capias. Which is it?
Should be a third-degree felony.
Excuse me?
It should be a third-degree felony.
It's a not in custody capias. Okay.
Yeah. So they're picking them up on a case that they filed.
They direct file.
Right.
Okay. All right. So, Mr. Perez, you're charged with a sexual offense, violation, failure to report name, or residential change. I think there was a previous warrant that was signed by Judge Colra. So is this something that I need to find probable cause on, or has probable cause already been determined?
I think probable cause already been determined.
State?
That's correct, Judge.
You see my question?
Yes, Judge. I'm seeing it here.
All right. All right, so I will find probable cause in case it hasn't been found in the past, but I believe that it has been determined previously by Judge Colra. And he issued a no bond capias, and so I will continue with no bond capias, and you can take it up with Judge Colra. Good to see you, sir.
All right.
All right, next is Kyle Paul.
Main jail. They're right there.
Excuse me.
Good morning, sir. How are you?
Good morning. Excuse me.
Yes, sir.
Can I speak to my public defender?
If you need time to consult with your public defender, absolutely. So, do you want to talk to?
Can we call him?
Yes.
Yeah, I mean, she's going to call you, and then after you're done talking, she's going to let me know, and I'll call you back up. Okay?
All right.
Yeah, because you always have a right to talk to your lawyer.
Yeah.
Okay, so if you could accommodate that, and I'll move on with other parts of the docket. All right, next is
Yeah.
Gino Zoria. Good morning, Mr. Zoria. How are you? Actually, I can't hear you. Could someone? Thank you, sir.
I'm doing good to my best availability. I'm a little cold, some
Very good.
unwanted situations happened last night, but it is what it is. We're all adults.
Good to see you, sir. You're charged with
Thank you, sir.
possession of a weapon or ammunition by convicted felon in Florida, and you're charged with 14 counts of that. You're also charged with count 15, possession of cannabis 20 grams or less, or synthetic cannabis 3 grams or less, and possession of cocaine. I'll hear from counsel on the probable cause, mostly directed at the number of counts. Hold on. I'm going to let counsel give me arguments first on whether there's probable cause.
Your Honor, based on the probable cause affidavit, it indicates that the defendant had,
The way and let me just cut to the chase. The way I view it, it looks like there's a charge for the gun, the magazine, and each of the rounds of ammunition.
That's correct, Judge. That's how the state's also interpreting the probable cause affidavit.
Okay, and you think that is a fair charge on the case?
Your Honor, at this current juncture, the state's position is that there is probable cause for each count, as there is the firearm, the magazines, as well as each round. So the state is requesting probable cause to be found on all of those charges.
All right, Mr. Ramillies?
If I may have a minute.
Sure. And you see what I'm getting at?
Yeah. Okay.
Not that I necessarily disagree with the state, I just want to be heard on it. I just want to hear.
Here's my problem with the probable cause, because I have a problem with the probable cause because this is going to be a constructive possession case, as you know, because there was somebody else in the car with this defendant at the time. The defendant is charged with it. I have some concerns that that, and I believe the case law bears me out that he can be charged with these counts, I believe. But I think you run into some problems, especially for probable cause, given that it's constructive possession. So as I see it, they have their probable cause for the gun and the bullet based upon the charges alleged and the way this arrest affidavit is constructed. But I don't believe they have the probable cause for the other. And by the way, it's more than 6 counts. It's 1, 2, 3, 4,
It's 14
5.
counts.
It's 14 counts, and as I see it, there's only 6.
What they're alleging is the firearm, the magazine, and each of the rounds individually.
Right.
And if I
Right.
may, Your Honor.
What?
And if I may, Your Honor.
Sure.
There's also allegations that there was a second magazine with
A second
amount
magazine, correct.
of the 6 rounds to the total of 14. Additionally, Your Honor, the second to last paragraph does indicate that the defendant made a spontaneous utterance that the firearm, the ammo, and the narcotics belong to him.
Right.
I'll state on my argument.
Okay. One more thing, Mr. Zoria, I also forgot to mention, I noticed that there is a 17th count also, a count of trespass property armed. I had forgotten to, hold on a minute, I had forgotten to inform you of that. All right, so I'm gonna find probable cause in this case. And I will leave it up to your lawyers to raise issues of constructive possession or otherwise in front
Can
of
I
the
speak,
district
excuse
judge.
me, I'm sorry to disturb you, sir. Can
Sure.
I speak with my counsel today? I haven't spoken with them all day before this appearance, and I'd like to speak about them, about a couple of the factors that are being reviewed in this case.
Surely.
Like for starters,
Don't say anything about the case,
Don't
sir.
mention about the facts of the case, but I will let you talk with your lawyers, just like I let the gentleman right before you talk. So go ahead over to the phone and you can talk to them, then I'll call you back up to finish this first appearance.
All right, thank you, sir.
You bet.
We'll come right back, right?
Is Mr. Kyle done? Yes, Your Honor. Okay, I'll call Kyle Paul back, please. All right, Mr. Kyle, have you had a chance to talk to your lawyer like we talked, like you asked? I'm sorry, someone has to turn the mic on. Thank you, Deputy.
Yes, sir.
Okay, great. All right, Mr. Kyle, let me start over again then. I want to let you know that you're charged, you've been arrested in this case and charged with burglary of an unoccupied conveyance unarmed.
Yes, sir.
I'm going to find probable cause for that charge, and I'm going to ask your counsel to give me their input and the state's input on what conditions of pretrial release I should consider. State.
Yes, Your Honor. The defendant does have several juvenile priors. On this charge, the state is going to be requesting a $1,500 bond.
State's requesting a $1,500 bond. Defense.
Your Honor, I spoke with Mr. Paul a few moments ago, and he
Thank you,
advised that
Deputy.
he is homeless, and even though he's from Broward, he has no familial support. He's currently staying at a program, and he does have a job lined up. He's very anxious about not losing this employment opportunity. He's 19 years old, and I would ask that he be placed on level 2. That was also his request. He's not able to afford any monetary bond.
Does Mr. Paul have an address that could
He's
support a
staying-
level 2?
He's staying at a program, and so his request was level 2. I believe based on his request that he would be permitted to have an ankle monitor at this program where he's staying. Is that correct, Mr. Paul?
Yes, ma'am.
All right, I will grant the defense request to place this, the bond at a level 2 pretrial release, no monetary bond. What program is he in?
What's the name of the program?
The Covenant House.
That's the homeless shelter. That's the, technically it's not a program. That's the shelter for homeless.
So that
You heard
doesn't,
me?
that, will that,
Might pose a problem because
well, he doesn't get out of custody until they have a bed available, that's for sure. Otherwise, if in fact they do have a bed available, can you supervise him at Covenant House?
if Covenant House would allow it.
If Covenant House will allow it.
According to his booking report, it states an address of 3121 North Prince 47 Terrace, Lauderdale Lakes.
Vince?
Mr. Paul, there's an address in Lauderdale Lakes. Is that somewhere that you have been living recently?
Yes, but I can't go there.
Okay, so you're no longer living there.
No.
Okay, is that what's listed on your identification card?
I don't know.
Oh, so you don't know how police officers got that particular address when you were arrested?
No.
How long have you been staying at the Covenant House?
For about like 2-3 weeks now.
Okay, so it's recent?
Yes.
Okay.
And he was on pretrial release? What was he on for those charges?
Showing that 2 of the burglary counts were filed.
That's all.
Shirley?
Just wait.
But Judge Port released him conditionally. As soon as he walked up, I noticed that there was competency issues. So so given his competency issue, I don't even believe that we can do anything here. This case has to go back before Judge Port. But what I would request is that you release him as you has done to Covenant House pending a bail. They will do that. And as to the other 2 cases, that, I'm sure Judge Port is going to move on that and get him before Judge Port while he's there to address his confinement
And
status.
is there a pretrial release issue with him having picked up this new case? He's out on RR.
Right.
Okay. All right, I'm gonna continue to keep the level 2 pretrial release pending the availability of a bed and pending Covenant House accepting the conditions of Mr. Pohl being on pretrial release. Those are 2 conditions. And if those 2 conditions don't come to fruition, then I need you to take Mr. Pohl's case back in front of the division judge because he'll be sitting there without the ability to get out. Thank you, folks. We got to lower that ledge right there, so you don't have to reach so high. Oh, I didn't do it again.
Yeah, I'm trying to speak to Zorilla.
Thank you. All right, next is Mr. Zoria back?
Your Honor, he's on the phone with him right
He's on the
now.
phone
So
with
you
him.
can address Walter Marion.
All right, Walter Marion. Is he in the main jail?
No, you can speak to me.
Is that main jail?
Mr. Marion, good morning, sir.
Good morning, sir.
Sir, you are charged with, you've been arrested for aggravated assault with a deadly weapon without intent to kill, another count of aggravated assault with a deadly weapon without intent to kill. Could you move the microphone away from Mr.? And possession of a weapon or ammunition by a convicted Florida felon. I'm going to find probable cause for those offenses and hear from counsel concerning bond. State?
Your Honor, for counts 1 and 2, the state will be requesting a $3,000 bond, and for count 3, Your Honor, the state will be requesting a $4,000 bond, as well as a no weapons or ammunition court order.
Vince?
Your Honor, I'm sorry, State, you asked for how
3,
much?
3, and 4.
3, 3, and 4. I did not actually have a chance to speak to Mr. Marion earlier. I would like to just speak with him to see if that's something that he can afford.
All right? Mr. Marion, what your counsel is saying is that she would like the opportunity to talk to you first before she makes an argument to me about what your appropriate bond is, okay?
Okay, thank you.
So she's gonna talk to you by phone in a minute, and I'll call you back up.
Okay, thank you.
Good to see you, sir. All right, next is Gabriel Taylor.
Medical reset.
To have the car searched. I was basically dragged out of the car.
Oh, could you go ahead and turn that off? Thank you. All right, next is Anthony Beauchamp. Anthony Beauchamp,
Medical reset.
medical reset, thank you.
Yes, and the next person also is medical reset, sir.
Jeremy Augustin, medical reset, thank
Medical
you.
reset.
And Ali Dume is what? Mr. Dume refused? He refused yesterday, from what I remember. Or there was a circumstance with him, he was up yesterday, I don't remember what it was, but he was unable to present himself, so. He's set for the 20th? From the 20th? What, is there anything you would recommend that I do? I mean, he can't just keep refusing because it's not in his interest. Yeah, State, what do you think?
State agrees, Judge.
I can do what? I do. Sure. Yes. Oh, wait a minute, let me think. Has someone already found PC? I think that Judge Lerner Wren had, on 3/20/20, it looks like Judge Wren already found PC, probable cause. So we just have the bond to talk about.
Judge, what's the defendant's name?
I'm sorry, it is Ali Dion Dume, D-U-M-E. And it's been a kind of a continuing refusal issue. And I'd like to take care of it if we're able to appropriately today. Because we had Mr. Dume yesterday, and it was a refusal yesterday as well. And apparently, it's been a refusal going back to the 20th.
I'm looking at his priors, Judge. He does have a 1996 ag assault with a firearm as well as a robbery while armed. 1997, he has 3 charges of robbery while armed. 1994, carrying concealed firearm. They would be requesting a $3,500 bond as well as no victim contact and no return.
Betsy, do you have any problem with us proceeding, setting Mr. Dume's bond because of his voluntarily absenting himself?
I honestly would prefer for him to be present, so that way we could speak to him about if he can afford the $3,500 recommended bond.
As would I, but this is the 3rd day in a row he has refused to present himself.
I would ask that the court just enter an order to have him brought by reasonable force, and then if we're unable to hear from him again, then we can address it in his absence.
Surely. hold on a minute, they're conferring, I want them to be able to, they're probably better than I, but I can only do one thing at a time.
Your Honor,
Okay, go ahead.
After conferring with co-counsel, I would ask that the court just follow the recommendation of the state, and then if there's an issue, we can address it at a later time.
Okay, and state?
Judge, I'm looking at an order here on Odyssey from Judge Diaz from March 19th, 2020, that the defendant would be released on ROR.
So we'd be asked that he be released on our, according to that.
If it's already been ordered. I mean, and it has been ordered
I'm
in
looking
this
at the
case?
order. Yes, Your Honor.
I don't know that Judge Diaz has handled first appearances.
This is a different case, Judge. It's an ad charge.
Okay, so that's not
I
this
apologize
case.
for that, Judge.
That's okay, that's okay.
We'd still ask on this new case that he be released our.
Well, I'm not inclined to release him ROR.
Okay, so if you're not inclined to release him, would you set a reasonable bond other than, there's some other stuff happening in this case, other than putting a bond at $3,500, because that's tantamount to no bond at all. So, he's ROR on one case, would the court consider setting the bond at 500, so at least give him an opportunity to get out?
I will,
Judge, if I may.
yes.
The state's concern is that the nature of the offenses are escalating. We just looked at a misdemeanor battery, and now this is a felony battery. The state is requesting a $3,500 bond.
Marion?
All right.
Give me 1 moment.
I'll issue a $2,500 bond in this case. And note for the record that the defendant has voluntarily absented himself for 3 straight days.
And just for the record, that BSO is not to forcefully bring him up here, because I don't want him to pick up a new charge.
No, I'm finding he's previously, probable cause has previously been found, and I'm determining his bond. So his next hearing should be in front of his division judge.
Okay, thank you.
You bet.
The state also requests a no victim contact order, Judge.
Of course, and no victim contact. Who's the division judge? I don't know. Okay, thank you. Into Mr. Zorillo? Okay, if we could call up Gino Zoria. Mr. Zoria, good to see you again. I'm sorry, someone has to turn the microphone on so I can hear you.
Is this button right here, sir?
Oh, thank you so
I've been watching
much.
it closely. Thanks.
Great, have you had a chance to consult with your lawyer now?
Yeah, I spoke to him a little bit about what was going on.
Okay, great.
Hopefully it made a change.
I just wanted to make sure that you talked to him. All right,
Sure.
Mr. Amelese. Could you turn the mic back off, please?
Okay, sir.
Thank you, we were getting a lot of back feed from there. Okay, Mr. Amelese. Could you speak into the microphone, please?
Just addressing the probable cause, he's charged with trespassing, possession of cocaine, and possession of cannabis. Approached it without telling us why it was suspicious. Said it was a flashing light. The case law is clear. Flashing light is not enough of a vehicle just sitting in one place to walk up a car and go and pull a person over. And so I don't believe that he gave the police officers probable cause to even approach the person, get him out the vehicle, and begin a search. In terms of setting a reasonable.
Okay, so let me address that. So I hear what you're saying. I'm going to find probable cause, and if in fact you believe those facts are ripe for the appropriate motion, I'd encourage you to do that in front of the division judge. Okay, now, as far as a bond.
So in terms of setting a bond, I would argue that this is overkill. He was sitting in his car, here's a he's released, he'll be able to work. He hasn't been in trouble in 3 years. He stays in the community. His mother lives in the community. So what I would ask the court to do is to set a reasonable bond on each of these cases. And if the court is so inclined to release him with an electronic monitor, if the court is if the court is not considering setting a bond, and if the court will consider releasing him on an electronic monitor. But this is I mean there's a lot of charges here, Judge. Just
State?
Yes, Your Honor, looking at his priors, he has a 2009 attempted murder in the first degree, as well as a burglary of a dwelling.
And how are those cases resolved?
They were adjudicated. As well as a attempted robbery with a deadly weapon, aggravated assault with deadly weapon.
Those cases were adjudicated too.
you need to not talk, okay?
Hold a minute.
I'm sorry.
Hold a minute, Mr. Zorrillo.
Sorry, sir.
Your lawyer's sitting right here, listening and being very active in your defense.
I'm sorry, sir.
That's
And
okay.
if you could turn that mic off, I would appreciate it. Thank you.
Sure. Sorry, guys.
I'm sorry, State, you were interrupted. Go ahead.
Yes, Your Honor. So, I'll start over. He has the attempted murder first degree, burglary of a dwelling while armed, attempted robbery, deadly weapon, aggravated assault with deadly weapon, possession of cannabis. These were all from 2009. He has a 2018 possession of cannabis. Your Honor, going back to the case at hand, the state's requesting on count 1 and 2 a $3,000 bond. On counts 3 through 14, the state is fine with an ROR. On count 15, the possession of cannabis, the state's requesting the standard bond of 100. On charge 16, the state's requesting the standard bond of 1,000. And charge 17, the trespass, the state's requesting the standard bond of 1,000.
If I may.
You may.
What I would be asking for is count 1 and count 2 to, if the court is so inclined, to give him an opportunity to bond. He can make a bond of 2,000. So if the court would do 2,000 each on count 1 and count 2, no objection to the ROR on the other counts, and I would be asking for the other counts where the state is requesting $1,000 that those be set at 500, given the nature of these cases.
All right. In the issue of bond for Mr. Zorilla, I will, on count 1, I'll issue a $2,500 bond. On count 2, a $2,500 bond. On counts 3 through 14, I'll ROR Mr. Zorrillo, which means released on your own recognizance. You don't have to pay any bond for that. On count 15, I'll issue a $100 bond. On count 16, I'll issue a $500 bond. And on count 17, I'll order a $500 bond. Thank you, Mr. Zorrillo. Good luck to you.
Can I ask you a question, sir?
Yes, if it doesn't have anything to do with the facts of your case.
Yes, it does. The probable cause for the trespassing, is it based on the homeowner?
We'll talk to you about that.
Sir,
We'll talk to you about that.
I'm going to suggest that you talk to your lawyer about that, okay? And what your lawyer can do now is, if he has motions to attack the legality of any of these charges, he can bring those in front of your regular trial judge, and I suspect that he will.
Oh, you want, who's my divisionary judge? Am I in a different court?
Yeah, I'm only your, as I mentioned in the beginning, I'm only your judge for this first appearance. You'll then be assigned to a regular division judge.
I'm not in rock court or none of that, right?
No, you're not in rock court.
I don't know where they're gonna, Very good. Good to see you.
That's all I wanted to know.
Bye.
That's all I wanted to know. So right now, as of now, what's my bond altogether?
Let me add it up.
Yep. 6,000.
6,000.
6,000.
So it's $600.
Yep.
Thank
If
you,
can
sir.
get a bondsman. You have a lot of questions. Somebody will answer your questions. And you're standing in front of judge, so could you stand up instead of leaning over the podium? You're in front of the court. Thank you.
That's
Okay.
from.
I'm sorry. I have a real raspy voice, and the room is completely empty. I didn't want it to echo, so you guys could get more feedback.
Okay.
I wanted you guys to have a silent.
Very good. Anything else I can do for you, sir?
Yes, sir. I just purchased my car, the one that's impounded. I have all my property in the car. I was literally just went through it with my family, and I was staying in my car, so that $600 bond would be a little hard on me right now, as of now, because I'm the only one that financially works. As for my daughter, Ayana Sarai, the mother of my child's not working right now because she has to take care of my kid at home, and I'm the only one that's financially providing for my daughter. I'm not trying to back and forth. I know, you know what I'm saying, we're all adults here. I know I made a mistake, and I know because of the mistake that I made is why I'm in front of you guys. But at the same time, I'm asking you guys to be a little lenient with me so I'm able to fix my mistakes and be a better man at the end of the day, and at the same time, still be a father and be able to provide.
Mr. Zurio, what I suggest is that you talk it over with your lawyer, and if in fact you want, I'm gonna stay with the bond that I said today, but your division judge can always change that under appropriate circumstances. And if in fact you want to go back to the division judge, once it's assigned to the division, and ask for their reconsideration of the bond, that's always possible. But I wish you luck, sir. Thank you so much. Are we ready for David? Are we ready for Walter Marion? Yes, Your Honor. Okay, Mr. Marion, come on up. Good morning, sir. Good morning once again. Have you had a chance to talk to your lawyer? I'm sorry, hit the button for, yeah. Have you had a
Yes,
chance to
sir.
talk with your lawyer? Okay, great. I wanted to make sure you did that. All right, as we were talking, you've been charged with one count of aggravated assault, deadly weapon without intent to kill, another count of aggravated assault with a deadly weapon without intent to kill, and possession of a weapon or ammo by a convicted Florida felon. I'm going to find that there's probable cause to support those charges, and I'll hear from counsel on your bond. State.
Yes, Your Honor. Ms. Pryor's.
Could you hit that button, sir? We're getting a lot of feedback from the room. Yeah. Thank you so much. I'm sorry, State, go ahead.
Yes, Judge. Looking at his priors, he does have a petty theft from 1989, as well as possession of cocaine from 1991, possession of cocaine in 1991, battery from 95, battery from 97, robbery by sudden snatching, 2003, grand theft, 2002, possession of cocaine, 2003. As for the case at hand, the state is requesting a $3,000 bond on count 1 and 2.
Much?
3,000 on count 1 and 2, and 4,000 on count 3, as well as an order for no weapons or ammunition, as well as no victim contact and no return.
Your Honor, I have no objections to the no return, no weapons request. I did speak with Mr. Marion. He just paid the mortgage for the family home. He resides there with several members of his family. He would have to have access to his cell phone in order to get assistance to post any monetary bond. He's unsure how much they would be able to afford. He was guessing at a $2,000 bond. So I would ask that the court set counts 1 and 2 set count 1 at 1,000 and then counts 2 and 3 at 500, and also allow him to have access to his phone, so entering an order to do so. And just based on the priors that were read by the state, they seem pretty old and they sound like they're mostly drug related. So that would be my argument this time.
All right, on count 1, I'm going to set a bond of $1,000. On count 2, a bond of $1,000, and on count 3, a bond of $500. I'm going to order no victim contact no return to the scene, and no firearms, weapons, or ammunition. And I'll give Mr. Marion a phone access order. Now, Mr. Marion, you probably heard me say this to some other people today, but as far as the order that you're not to contact the alleged victim in this case, that means not to contact the alleged victim in this case at all. As I've said before, that means you can't be in the same place at the same time that they are. You can't be near them. Second, you can't contact them either by phone or by email or text or any other way, and you can't have anybody else contact them for you. Okay, do you understand that?
Yeah, Your Honor, but it's just this. We got one problem. The house belongs to the family that I lived at. That's where I live at.
So this incident took
And
place
so
at your
yeah,
residence?
where I live at, yeah.
So are Peta Brammer and Abel Nichols family members that live with you?
No,
And don't speak about the facts. I just want to know their relationship
Yeah,
to you.
yeah, no, they ain't family members. They just one of them is a friend, and the other person don't want to stay there at my house.
So none of them stay at the house?
No, a BB do, a BB.
Who's
That's Nichols.
oh, a BB does.
Yeah, that's my best friend son. I was coaching him on trying to get off of drugs.
Is it your house?
It's a family house.
So it's not your name on the documents?
No, my name is not on the main document.
Do you have anywhere else you can go and stay?
No.
And one of the victims lives in that house?
Yeah.
Yeah, Mr. Marion, I'm gonna stay with the no return to the alleged scene of the crime. So those are the terms of the bond. I thank you very much, sir.
All right.
Yes, ma'am. And what did we do with Mark Perez? Oh. Right. All right, so could you give me Mark Perez file back again, please? Okay. And that's the capias that Judge Cora signed?
I believe so, Your Honor.
Okay, let me take another look at that. Thank you. I saw something that Judge Cora signed. Says, what's the defendant's name again?
It's for Perez, Mark.
Mark Perez.
What is it? It's sexual offender.
All right, so let's go back on the matter of Mark Perez. It's case number 20-301 CF10A. I had previously ordered him held on no bond, and I've been told that he's entitled to a bond, so let's address his bond status. God bless you.
Thank you, Your Honor.
State, what do you recommend as a bond in this case?
Judge, I'm looking at his priors. He has a 2019 failure to register as a sexual offender that he was adjudicated on. As well as a 1995 sexual battery on a minor victim that he was also adjudicated on. 1995 possession of controlled substance, adjudication. 1995 possession of drug paraphernalia, adjudication. The state's requesting a $5,000 bond in this case.
Defense?
Your Honor, since he's no longer here, I have no ability to speak with him about that. However, I did see from the PC that it looks like this failure report stems from his release from prison, so I'm assuming he did some prison time based on the most recent failure to report that the state cited to. The other cases are fairly old and seem to be the reason why he's on this particular status. It looks like from the PC he was trying to get released and have a temporary address so that way there wouldn't be any issues, and we don't know because I haven't spoken to him about the facts, but there may have been some confusion as to whether or not he thought he was able to use that address. I would ask that the court set the bond at a little bit more reasonable amount, just based on the fact that he was in prison. He probably doesn't have access to a lot of funds, and I know that housing is very difficult for individuals in this category. So I know that pretrial would be an issue, so I would ask that the court set it at $1,000.
Okay, I'll set the bond at $3,000.
Thank you, Your Honor.
Thank you, folks.
So you trust this guy? Okay.
Thank you. Thank you, ma'am.
Now there's just David Palacio.
That goes to you.
You should handle this one.
All right, and the last paperwork that I have up here is for David Palacio.
Don't know where he is.
He's a medical reset on loan. All right, and does that complete our docket?
Yes, it does.
Well, thank you, folks. I want to thank everybody up here who helped me, especially people who had patience when I forgot to sign the forms and sent them back to me numerous times. Thank you, folks. We'll be in recess.